Hi, everyone, and welcome to the Immigration Lawyers Podcast. This is going to be a recap of events going on March 12th, Sunday, till March 18th, 2017. I have a lot of interesting information and tidbits of information and just practice tips, reviews of certain legal stuff. Just a lot of good information to listen to. I'm going to talk about naturalization, EB-5, musicians going to South by Southwest and not being allowed in and why that was. Some issues going on with lawyers in our practice that are messing things up. The travel ban, new legislation, consular practice, a lot of stuff. So I hope you enjoy. Welcome to the Immigration Lawyers Podcast. I am the host, Attorney John Khosravi, and I practice U.S. immigration law exclusively. For more information about the program, please visit www.immigrationlawyerspodcast.com. Please note that this recording is informational only and does not constitute legal advice. Please consult with a licensed attorney for specific legal guidance that suits your case. Also, this recording is copyrighted and written permission is required for rebroadcasting. For more information about me, please visit www.jqqlaw.com. So to start off, last week I talked about naturalization cases that have been delaying a lot more than they usually do. And these are the cases with the IOE designation and the receipt number. And I got a lot of good feedback with a lot of people had the same issues, and they were from countries all over the world. They weren't necessarily Muslim countries. The interesting thing was one gentleman, a good guy, said he requested an expedite request to the field office, and it worked. Now, I did a similar thing, not with much documentation, but to a field office in Chatsworth in northern Los Angeles, and didn't get a response when I sent it by email. And that's usually the case in LA when I emailed officers or supervisors. As nice as they are when I meet them in person, they never respond to my emails, even though they say they will. So that's kind of disappointing. But so that's just something we have to wait on. I did call USCIS on Friday morning, and they said they're currently working on cases submitted on June 20th. Now, they say that, but not one of my cases, but another naturalization case that was in May 2016 that was submitted still hasn't received an adjudication or an interview. So that's their timeline. That usually doesn't work, but at least once it passes the date, you could do an official complaint about the issue that things are taking too long. But when I was having this discussion, it came up, just one of these things about naturalization is, can you file naturalization when a person is outside the country? Now, for doing an advanced parole travel document, the person, or any travel document really, a reentry permit, you have to be in the country to submit it and also be here for the biometrics. Now, for the I-765 work permit, a colleague said that that's necessary as well. But when I looked in the statute, it didn't reference that at all, that you had to be here for I-765 Employment Authorization Document, EAD. So the I-131, I know for sure you have to. I-765, I don't think you do. And naturalization, I've been searching, and to be safe, I always tell people to be here, but I couldn't find anything in a rule written that said the person has to be here for naturalization. Now, they have to live in a state for 3 months before submitting. They have to be resident of a state. And I've had people come to me after I got caught up in that mess. But the naturalization being present here, that's something that I don't think you do. It's probably safer to have me in the U.S. when you file. But if you know with the statute or the rule that says differently, please let me know. And this popped in my head, the big issue everyone's always having is, do you need to have a valid green card when you file? Now, at our field office in LA, they said you have to have 6 months of time on your green card before you file. So that means you have to renew. And that's a safe thing to do. However, I've seen it all the time that they let it go, and if a person hasn't renewed it. I always just tell my clients to renew it. You don't want to create problems and create more delays, even though getting I-90 done is taking like 6 months. But I think it's a field office by field office thing. And if you have any specific statute you can find, INA, CFR, or wherever, that specifically says that, I would appreciate to get it to get a final answer on this, because this is one of those things on the listservs. Every couple of months there's a discussion about it, and it's kind of vague, and I haven't been able to find an exact answer to that. Now, moving on, last week, or just ending now, I think, the South by Southwest Music Festival was happening in Texas, in Austin, Texas, which is a big draw. It gets bigger and bigger every year, with musicians from everywhere coming to enjoy the music and technology and all that kind of networking that goes on there. I haven't gone before. Maybe not go next year. I'll see. But one thing that's been in the news is musicians getting stopped by CBP and denied entry into the U.S. because they would come in with a B1, B2 or a visa waiver, and the issue then came up of like, are they going to perform or not? Are they getting paid for not? Is this unauthorized work? And so, a lot of people hear this and they start bashing CBP, especially under Trump, saying, why are they so hard and they're being mean to foreigners and that. But the reality was this has always been the case. Musicians have it pretty strict. If you're a professional musician, you're coming to the U.S. to do anything music related, perform that is, you need to get an O or a P or have some sort of exception to the visa waiver or B visa that you have, like if you're doing a foreign cultural exchange program thing. Now, amateurs do have an exception if you're not a professional musician or get paid for it, but you're coming here to audition or do some sort of charitable event. That could be okay, but if you're coming in to perform, that's going to be a problem. And what one of these immigration lawyers that's at South by Southwest said, there's some sort of audition exception, or here's another terminology used for it. But I think that's probably works. And if you're just coming to South by Southwest to audition so people can see your work and something happened from that, that's probably okay. But it seems, based on news reports and from my experience with the news, you can never fully trust what they say. Just there's so much, especially when they're talking about technical legal stuff, they might say things wrong. But these people that were coming and they were banned, and there were several of them, and they weren't Muslim or anything. They're all from all over the world. It's Italy and that kind of stuff. The South by Southwest part probably would have been okay, but they also had other gigs lined up. And they said they weren't getting paid, for example, on some of those cases, but the venue was getting paid. So in effect, they were performing at the venue, and the venue owner was getting paid, for example. And that's a violation because that's not an audition, it's a concert. And the idea behind all these is that, an American person or U.S. citizen LPR, someone with authorized work permission, could do that gig and make money. And by just doing it for free even, they're undermining the U.S. worker. So, it's a hard thing because it's kind of weird because you want the free cultural exchange of musicians coming and going and performing here. I think that's a good thing. But at the same time, that's against the regulation. So CBP, when they catch it, they're technically doing the right thing. But society-wise, it's one of those things to think about as a policy. Do we want a fair exchange in music? Now, there's that foreign cultural exchange exception where if a foreign let's say France wants to do some sort of cultural exchange program and they're having their citizens come here play, as a policy, that'd be nice. But what about the broader extent that people just wanted to come here to do music and express that? There is the issue of, unions here, music unions here might have a problem with that because it could undermine the wages of domestic workers. And I bet there's millions of fans internationally that would love to come to the U.S. and play. It does create a policy issue. So I don't know which way to land on. I always like the free movement of people, but the domestic constituency of musicians here in the U.S. could have a problem with that. And so it's harsh, but there is some policy reasoning behind not letting foreign musicians come and perform here willy-nilly. And I get this all the time. People wanting to perform, they have small gigs, and they want to come here, and I say, listen, you don't qualify for an O1. Now, I've seen some O1 cases, like I've had people come to me for EB1, and another lawyer did their O1, but they just didn't want to work with that lawyer for some reason. And they would come here to my office and bring their O1 case, and I would review it. I'm like, oh my God, this person has nothing. I can't believe this O1 is improved. So O1 isn't that hard. I've seen some very weak O1s approved. Because I'm so strict, I would normally turn it down, but I say, maybe go to another attorney. The amount I'm going to charge is going to be too much because I can't with confidence say it's going to get approved. But they do happen. Now, in line with these denials, there was a news report that the Tibetan soccer team, or football team as they call it, the female team, was denied visas. I think they didn't say in the article, it's a BBC article, they didn't say specifically that they got the O or P visa, but I think they did. I mean, they got the status approved, but then when they went to the embassy, it was denied. And obviously the State Department doesn't comment on these things. But, Tibet is one of those countries like Iran where if you come and are able to enter the United States, it's a pretty easy, high rate of success asylum approval case. And that's why they're afraid of allowing those to come in. Now, it's kind of harsh for the national team, especially to compete in some sort of competition, to cut that out. But that's just something that happened. It's very harsh because it probably cost them a ton of money with all those players. Maybe did premium processing and do all that, pay the visa fees, pay USCIS fees, probably had a lawyer do all that kind of stuff. And Tibet isn't necessarily a rich country. So and that was a harsh consequence. to get denied, and that's kind of sad, and it's not good PR for the State Department, but it is how they do it. But the bad PR that's been happening with regards to U.S. immigration has been pretty bad. The new travel ban came, and it went temporarily at least. Two judges, one in Hawaii and later one in Maryland, posed temporary restraining orders on this. And the Hawaii one was wider. They're both national, but the second temporary restraining order, the TRO in Maryland, only banned the portion from the 6 countries. They didn't go into the other areas of the bill, other sections of the executive order. The Hawaii one wasn't as grand either, because it was good because it did the it stopped section 2 and 6, I believe it was, which references the refugee portions and the 6 country portions. But the interview waiver program is out. So about, like, I mean, it's hard to say what percentage it is, but only 2 of the sections in Hawaii were put on hold until the cases move up the court system. So other parts of it are still valid. We'll see what happens. I still see it going both ways. It really is a coin toss to me. I don't necessarily think a president can't ban people from certain countries coming, especially when they have an ongoing war called the War on Terror. And again, it's not my saying that even makes sense that we have this indefinite war that goes on forever. But when they create these philosophical wars with no end in sight, crusades, if you will, under that banner of national security, anything goes. That's something we really need to, on a constitutional basis, really challenge. But I don't think that's going to happen either. So it's fair game. Anything can happen right now. But it's been a mess just regards to the effects of this executive order and the effects on people. So on one end, it's not just the executive orders. I'm planning to do this one special section that keeps up, as part of the Immigration Lawyers podcast, that keeps up with all the legislation that's happening and follows up on it, like on a monthly basis. I do an update of what's going on. And I was like really excited to do this thought. So I went to the government.gov website that lists all the bills that come in. So I'm like, okay, there's going to be like 3 or 4 bills. I'll constantly read them, update them. I'm still going to do this. But once I put in the word immigration in their search feature, there's like 10 cases, 20, 30, 40, 50, 60, 80, 90. There's so many immigration-related bills that are happening. It's taking me tens of hours to go through them and organize them since this congressional season started in January, that it's overwhelming that how big a topic is. Now, I started this year. I haven't been tracking immigration bills before this. Maybe 2015, 2016 was the same situation, but it's crazy how many bills there are, and they're all over the place. And there's pretty horrible ones, and there's good ones, and I guess whichever side of the spectrum you're on, for you is going to have a good and a bad. But I'm going to try to cut it down to get the ones that are most the biggest surprises and the biggest issues to talk about. So we can use this constituency we have as immigration attorneys, and the fact that we have our book of business that's thousands and thousands, just the people listening to this, of citizens from different jurisdictions, and they have family members. So we could really be a voting block, if we put it all together to challenge the really crazy ones. Like there's this RAISE Act by Senator Tom Cotton, and he wants to get away with getting green cards for your parents when you're a citizen, for your adult children. It also includes diversity visas going away and all this kind of stuff. And so it has to be pushback on that. I don't think that one's going to happen because it's just so out there. But nonetheless, having a voice to say we're not down with this kind of stuff is going to be very important. So something I'm going to be continually talking about. But on the other end, I'm getting, last week I talked about getting a lot of calls from people that are finally going through with their green card process for a U.S. citizen for their spouse, a foreign national that's here unlawfully or legally, and how many calls that I'm getting. This week I've been getting a lot of calls. I got 2 or 3, so that's a lot in my sample size. But people that paid immigration attorneys maybe months ago, maybe years ago, that the attorney got the money, never did anything, I never filed anything, and just disappears, and they call, and so one person was calling me, telling me they contacted the bar didn't do anything. They contacted malpractice attorneys, they said we can't help. Person spent $10,000 on a waiver, and nothing happened. And this is terrible. This is so terrible. And we have to, as an association, as a group, because the bar doesn't care about immigration lawyers. If you're in California, there's no interest section for immigration lawyers. We're under the international law banner, which essentially means that we're nowhere in existence and we're the black sheep of the practice, whereas California is the top immigrant state. We should be the most dominant group in the California Bar Association. And there needs to be policing of that, because every time one of these terrible, terrible lawyers does something, then all of us get painted like that. So we have to police ourselves. Let's put aside the notarios that are killing the look of our profession. We have to police ourselves. And so have their names. Now, listen, if a lawyer is taking $10,000 from a person and just not caring, that's a pretty harsh person. Who knows what they're going to do if you go and attack him publicly. And I don't really want to get involved with that. But we have to develop some sort of system. And I have plans on this, but it's such a political thing and such a long-term thing. The idea is building an external association from the official bars that is within the immigration lawyers groups, that we police ourselves. Like, to be a recognized immigration attorney that's worth hiring, you got to be a member of this group. And we're going to have open and transparent methods of judging people, kind of like an avo.com, but better, because it's going to have personal attention, where you have to be a member, you have to pay some money to be in this group, because that money goes to researching the attorney, make sure they have good background, make sure they've gotten cases approved, having feedback from people that potentially complain about them, and be able to do some internal policing, and having a badge where people come on their website to say, I'm part of this group, to show that there's some consequences to these kind of actions. Now, there's no excuse for immigration attorney not to contact their client back, not to return their calls, to take money and disappear. That's the scumbag territory. That has to stop, and we have to police that, because it ruins it for all of us. And then you have these, like in California, there's a state representative that's constantly trying to attack immigration lawyers and paint them in a bad light, apparently, allegedly, because she was hurt somehow by what she thinks was an immigration attorney. And so we can't let these bad apples ruin the barrel. But that's the case with how people are dealing with this. Now, last week I was talking about how CBP is getting a bad rap on all this because of the amount of pressure they're under. Now it's actually the consulars. Now, I had two cases that were people from those 6 nations that were supposed to get their visa. And the administrative processing ended like a few days before the travel ban was supposed to go into effect on the 16th. And so they were asking me, like, should we go and pick up the visa or no? And I was like, if you don't mind spending the money to give it a shot, because to go at the embassy and try to pick it up. These are people from Iran, so it's not easy for them. They have to travel to third-party countries. And so both of them did. I said, I don't know, really. Like, do what you want to do. It's a risk. And both of them went, and surprisingly, both Ankara and Abu Dhabi issued the visas really fast. I was pretty certain, I would have bet money on it, that they would have just dragged their heels and said, I don't know what's going to happen with the executive order, so we're just not going to issue visas during this period of time. I could easily see them doing that kind of stuff. And it didn't happen. They actually issued the visas. And the people were able to come. But I got to say, this is a lot of pressure on consular officers not knowing what to do, whereas one day they have to do it, one day they say they don't. And then, everyone goes to interviews looking at them like they're the guy or the girl or lady who is creating problems for them. So that puts them in a very difficult space. And then they have to do more work now, because they have to adjudicate the waivers if that executive order does end up coming through. So that's more work for them. They have to write up more stuff, get explanation, and it just creates more work when they're already busy as it is. On top of that, the funding for the State Department is going to be cut probably by, I don't know, a quarter or a third. I'm not sure if that goes out of the consular budget or if it's the other aid programs that they're doing. But if it is the consular program, or at least it affects the State Department in general, that's just an additional burden on them. That means very likely MVC isn't going to get any more money, and that's just going to cause more and more delays. We already have administrative processing happening with people all across the world, especially these 6 countries. That's probably going to increase in time and create a lot of stress. Now, one of the cases I did have that was able to get the visa and miraculously the day before the executive order. So even if the executive order does go into effect, they still have their valid visa before the 16th, so they will get it. And the gentleman actually entered the U.S. immediately. He's like, I'm not messing around. He got on a plane and came immediately on the K-1. And it's been some discussion about whether a K-1 is an an appropriate type of visa to use. I don't do K3s because the delay, and I haven't looked at it recently, but the delay in doing a K3, which is like a marriage case I-130, and that allows the person to come faster if there's some sort of need to enter the U.S. faster and do the adjudication for the green card in the U.S. The K-1, which is a fiance visa, for a couple of years I wasn't doing, like I think 2014 or something like that. And the reason was because the delay was so long that I just tell my clients it's probably better you get married, because at least if you're doing consular processing, when you enter, you have the green card. The K1 is taking so long anyways, it's not worth the time, because K1 you got to do, the initial application, you got to go to consular processing, they come here, they have to do USCIS again. I've seen cases that did K1s, they filed the I-485, they waited a year to get the adjudication of that done to get the green card. And this is really annoying on people because they're constantly waiting and stuff. So it was something, because it increases attorney fees, increases government filing fees, there's more interaction with the government, opening up space for something to go wrong. So it wasn't something I do. Primarily it was for the delay, because I'm like, if the difference between the K1 was a month, then as opposed to getting married, just get married and do this a cheaper and more efficient process. But on the listserv, the immigration lawyers listserv, I posted this question and I said, how long are your cases taking? And I saw that the times that shifted, and I asked this a couple of times and did like a survey, and from it was taking 6 to 8 months on one survey I did, that was going down to a few months and a couple weeks. And so once I saw that, I immediately started telling people, my clients, that K1's the way to go, because when you're doing a fiance visa, that means you're in love, and you don't want to be separated from your loved one that much. And so at the end of the day, it's a matter of love or money. And I wouldn't want to be separated from my significant other, or my spouse or future spouse. If it's going to be extra a couple $1,000s in fees and this and that, then so be it. It depends on everyone's financial situation. But I definitely want a K1, so I don't dissuade people from doing that unless there's a reason. Sometimes we have couples that the U.S. citizen spouse, for example, very easily goes back and forth to the third country, the foreign country, and can spend a lot of time with their fiance, so it doesn't matter. But if it's a situation where they're here in the U.S. and the other person's overseas, to me it makes sense now, because I'm getting K1s approved in 6 to 8 weeks. And that's super fast to me for USCIS. 6 to 8 weeks, you get a petition done. Then once it's approved, within a few weeks, gets sent to the consulate. And if it's like some European, consulate which are fast, they could be here in no time. Now, if this particular one was in Abu Dhabi, Iranian national. So the K1 took 6 weeks, which was amazing. But then the administrative processing at the consulate or at the embassy or in Abu Dhabi, UAE, took 8 months, 8.5 months. And so the clients were frustrated. They're like, well, why don't we just get married? But I'm like, no, if you get married, it's just going to go back in line. First of all, they got to adjudicate the I-130. And once that's done after 4 to 6 months, or maybe more, it's going to be transferred to NBC. NBC is going to be going through its process, which would take many months, especially for an Iranian client where there's less interview positions open. So once we get through the consular processing route, which ideally would take like a few weeks, but NBC gets backed up, so it takes months. For them to, once they receive all the documents, to schedule a time at the embassy for Iranian case, easily additional 4 months right there. That's what I'm dealing with right now. So then they go to the embassy, do the interview, and that same administrative processing is going to happen all over again. They're just probably going to restart it. Maybe you'll get lucky and it'll be a day administrative processing which happens, but I wouldn't risk it if you already have something that pending. So just stick with it. Now, I'd like to hear from you. Please email me, info@jqqlaw.com, if you have a different opinion, because I'm always trying to do the best route for my clients. And at this point in 2017, the K1 is the way to go. If it was 2014, 2015, I would go I-130, what is it called? The conditional residency, CR1. But right now, that's the way I would go. So email me, let me know if you have a different opinion, why that is. I understand, marriage, the costs are less. That's a no-brainer. But at the end of the day, if you want to be with your loved one, speed is the way to go. I've had a case, and this was a green card holder marrying for national. After 2 years relationship, the distance broke them up. Now, it wasn't a solid relationship as it was. I could see it happening from the beginning, but these things happen. Maybe if they were together, they would have been able to grow and deal with the issue and maybe overcome it. But that 2 years, and it really sucked, because 2 years, I-130 got approved, waited for consular processing, that was finished, interview was set. after two years and a couple months, like a month before the interview, fight happens, and they're like, actually, we're breaking up. And so it's just like all the work was done. I was at the last end of the marathon. And speaking of marathon, I'm in Los Angeles right now. I was gonna record this in the morning. This episode. It's Sunday right now. But the LA Marathon goes right by my house in West LA, and the sound of the music and people cheering and screaming made doing a recording impossible. So that's a little fun thing that people are out to have a good time. So I ended up just going outside, having a hamburger at the local Whole Foods they were making, and just watching that and seeing all the people. A lot of people were walking. I was surprised. I did it's a fun run, Beta Breakers in San Francisco, which is nothing. I don't know. It's like 7K or something, and we ran the whole thing. Now marathon is obviously a lot more. There are a lot of people walking towards this last part. I'm on the last 2 miles of it on San Vicente before it hits Santa Monica and the beach in Los Angeles of the marathon. So, but I was surprised how many people were walking. I would have expected more running going on with the amount of training they go. But I'm not going to judge because I'm not going to put myself through a marathon. I don't think I could handle that or have the time or patience to train for it. But if you did partake in the marathon, great job. That's a big thing to accomplish. It's all the training and time. But definitely congrats to you. Kudos to you. Now, onto a sadder note, which is kind of bittersweet. I had my first client pass away. And that was shocking. The family text messaged me actually telling me what had happened. There was a gentleman who had his green card many years ago, but went back to his home country and was just over there. He didn't feel like living in the U.S. And so 10 years go by, essentially the green card's abandoned, and that he was getting very old and he was sick. And so the family said, we want to bring him back here to be with us. His wife was a U.S. citizen, daughter was a U.S. citizen. So we just did a petition. And the surprising thing was the petition was approved in 10 days. An I-130 spousal petition approved in 10 days by USCIS. That blew me away. I thought it was an error. But, I mean, he already had a green card, so that probably had a lot to do with it. He already had a number. But still, USCIS getting I-130 approved in 10 days is amazing. That was like a crazy situation to deal with. But I-130 was good. We did consular processing. Went there. That was good. Until it went to the embassy. When it went to the embassy, we sent a new I-864 affidavit of support. And this is in Armenia. And our worry was, and the client had gone to another lawyer, which they did all their immigration stuff to. And that lawyer said, the father, the beneficiary, is too sickly. The embassy is going to deny it. And they weren't happy with that, so they came to me and they said, this is what the lawyer says. And I said, what kind of sickness does he have? And they say, just old and just breaking down. Now, as soon as he came here, poor guy found out he had like cancer and this and that. By the time they just say he's just broken down guy because he's old. Family, all of them well established, a lot of money, 6 figures. So I said, I don't think that's a problem. You have the money. Now, when you read the Foreign Affairs Manual, it does break down the stuff that could be a problem. There's like 6 or 8 kind of stuff about sickness that could be a problem. He had 2 of them, really. But, he went to there. I added extra tax returns from the other children and say, listen, these people got money. Like, they'll pay for whatever is necessary. The problem they had, which delayed the case a little bit, was that they said the signature wasn't good on the I-864, the sponsor's signature. They wanted a new one. I said, okay, that was kind of weird. So we had to fill out a new form. I had them ship it directly to the client. Now the situation, again, this was an Iranian case. So for an old guy like that was falling apart, to go from Iran, travel to Armenia to interview, get the temporary denial, go back, wait for FedEx of the new document, then go back over there, that was a big hassle. But once they got the new one, they approved it really quick without administrative processing, and he was here. And this was a year ago, and I just got the text, said, he passed away. He was very sick, and it was very sad. My first client that passed away, just for the family. But I was happy, and this is the humanitarian side of our work is, the guy was at the end of his life, and he got to spend it with his children in the U.S., and it wasn't a taxpayer burden. They had money. They took care of all the end-of-life care. It happened very fast, too, so it wasn't one of those things that cost a lot of medical bills necessarily. But, I got to bring a guy to be with his children throughout his life, with his wife, he had four kids, and that's a way to be. If you're gonna, if once at the end of life you want to be with your loved ones. Obviously he grew up and was raised in Iran. He spoke that language. It was easier for him to live in his home country. But you want to be with your family when you're on that stage of life. And through immigration process, we were able to do it. Now, they would have been happy with getting a tourist visa. A lot of my clients who come here where I get their green cards with their parents, they just want to get a tourist visa so the grandpa could come see the grandchild, get married, and just come and go. But frequently they have denials. So when they do come to me saying we're trying to get a B1, I say, listen, if you have time, just get the green card, because they're going to go back and forth and get the B1 denied. I could say, or B2 denied. I tell them, give it a shot. Go do a B2. Once it gets denied, then we do the I-130, just so you could at least test the waters out. It's a cheaper way to do it. But frequently they're denied. And so I just say, listen, just get the green card, and they just haven't come. Essentially, the green card is a tourist visa, but we have no choice because of the way consular process. They're adjudicating these things. On another sad note, again, this is for educational purposes. I talk about this, but I have one of my business clients who had a cousin, a young kid, really a teenager, got diagnosed with horrible cancer. And like in the worst case, and like 2 weeks, all of a sudden he went to the hospital sick, massive cancer, and his family is from one of those 6 countries on the executive order list. And so the guy gets diagnosed early March. Family tries to get everything together to come here, goes to the embassy, get the visa. They're not sure what to do, and this and that. Eventually, it gets issued the day before on the 15th, and they want to board, but they're in Saudi Arabia at the time. They're nationals from those 6 countries, and CBP there wasn't sure whether they could board or not. Anyways, a lot of back and forth. Eventually, they were able to get on the plane, and the client contacted me and said, listen, could you help us out, make sure they could get out of the airport once they arrive in LAX? And so, as I said, I'm in communication with the CBP officers. They're wonderful officers. And so I emailed them and I said, and this is something to do when you have cases, and I'll talk about the situation more, but I emailed them and I said, listen, I have this case, I have the doctor's letter, this kid 19-year-old kid has horrible leukemia and kidney failure, or liver failure happening. It's bad. The family's coming, mother and 2 brothers, please facilitate it so there's not any issues. So client was happy I did that. CP responded immediately. This is at 9 p.m. at night. I don't know if I'm sure if the officer wants me to say her name, but she's wonderful. And so she forwarded it to the section chief that was in charge on Saturday morning when they arrived. And the mother and the younger brother they came in customs, no problem. The other brother was held for a year, but honestly, looking at his name from his passport, he had a hardcore name, which I was like, oh, I can't say the name, but if you saw the name, I was like, okay, there's gonna be some holding. But they kept him for 50 minutes or so, secondary, and then they let him in, and everything went smooth. And now the family's together during this dire time. So reason I mentioned this is that there's cases, for example, you have a couple that are married, and one's a U.S. citizen, one's overseas. The overseas person wants to come visit, but there's the fear, especially if, for example, there's an I-130 pending. There's a fear that they come to the airport, then they say, oh, you have an I-130 pending? We're afraid you're going to have immigrant intent, you're going to try to stay here, this and that. And so that becomes a problem. They might get denied at entry. Now, I had a case this week where a guy said, I met this woman in Singapore, we fell in love and got married immediately, and then we came to the U.S., she had a visa waiver, and we came together, and officers didn't say, what are you doing? Like, oh, we just got married, we're having a good time. The officers didn't say, they said, so okay, come on in. I was like, wow, I'm always worried they're going to block him, but it happened. So that happens both ways, but it's so harsh. If the client is down with doing consular processing and they have an I-130 pending, you could contact CBP beforehand, let them know, this is the flight they're coming in, this is their passports, they have no intent to adjust status in the U.S. You're telling them beforehand to just put on the record there's no immigrant intent, so if they do try to adjust, that's a fraud situation if they lie to an officer. But if it's not worry that they're down to go back to their home country to do consular processing, CBP is down. When I asked them, they said, what triggers it is I-485 filing. That's when they have problems with coming in, but I've seen it happen both ways. I have another client that they've been dating a long time, and when the officer asked where you're coming here, and said, oh, I'm coming to see my boyfriend. The officer said, are you planning on getting married? And she says, well, I hope so. And they took her and put her secondary for 2 hours and addressed the situation. So the stuff like that happens. So if there is a situation where a married couple coming to visit, or some immigrant intent issues, some things that could potentially look like, inadmissibility for intent of coming here and changing status or something, You could notify CBP beforehand, and every, I guess, office probably does it differently, but LAX, you could email them and let them know, and so when the person comes up after exiting the airplane from international flight, they can already be flagged that this person has, had admitted to the fact that they have these situations that potentially could be a reason for not allowing to enter, but, we've dealt with that. And you could talk it out beforehand. So that's an option that exists that's worth trying. Now, moving on to some technical stuff, looking at the Oppenheim visa bulletin talk, and apparently it looks like EB1s for China, India are going to start filling up. The current table is going to be adjusted in a couple of months because of the high demand for EB1 categories, which absolutely sucks. I know a lot of people that were Chinese, not my clients, but my colleagues who had Chinese EB5 cases that were trying to fit in on an EB1A extraordinary talent, or they had made businesses that were trying to get it here on the EB1C, International Executive Manager kind of program. And if that fills up, that's going to be a pain. I have Indian L1s who would love to, are here eventually to try and build a company to be able to get the green card EB1C, and that's going to be a pain. I doubt it's going to be that big a backlog, but nonetheless, that's one of those annoying things that happen. On the other side, the statistics for EB5 program were released by the State Department for 2016. Breaking down the visa statistics and of the immigrants' origin and what kind of investment they made. I'm potentially going to do a separate video on this, but suffice it to say, almost 85% of the EB5 program is East Asia. China, Vietnam, South Korea, Taiwan, Hong Kong. What was the other? There's one more in here. I can't ready to find it right now, but there's one of smaller, or Singapore. So, and Singapore is only 0.2%, but nonetheless, East Asia is EB5 territory. Now we have India growing, Brazil, but they're nowhere. India and Brazil together are 3% compared to China's 75.6%. So it's up there. Now, an interesting thing when you break down the numbers is that obviously, 90+% of the program is in regional centers with TA designation, which means, the $500,000 investment. And with regards to just the EB5 program, anybody's guess is what's going to happen with the new rules and change in the regulation, increase in fees, regional centers going to continue, blah, blah, blah. We'll have to have another episode about that. But what was surprising to me is that, of the direct investment, non-regional center investment, which there were was almost 7% of the cases, so nothing significant, maybe 600 cases or 700 cases. The large, more than half of them were $500,000 TA designations, meaning the foreign immigrant was investing only $500,000 to get the EB5 green card. Now that's very troublesome to me because, I'm not down with that. It depends on the business they're doing, but I'd be very cautious as a foreigner coming to invest $500,000 in America and expect 10 jobs to be created in the highly bureaucratic taxed system we're in right now, to allow $500,000 alone to do that. Now, these people might have partners that put in then a couple of million with that or something like that, that boosts the dollar amount. But I get calls all the time from people who want to do $500,000, and I say, I don't know what you could do in America with $500,000. You may hire 2 employees in a small place, but expectation of 10 employees, you got to have big money with it. And the regional centers do that in some ways, maybe getting other loans, getting other investors, having techniques, this and that. But I'd be very cautious about doing direct investment with only $500,000 unless the person has a lot of experience doing business in the U.S. and partners with heavy pockets to be able to help that process and help them out. Now, going back on a separate thing about bad lawyering, I had an L1 case that was just butchered by this alleged attorney that didn't even include a G28. And so that really annoys me when clients come to me and they say another attorney did something and didn't submit a G28. And that's just that's horrible. And so this is just a horrible situation. It's informational, especially for newer lawyers or just people that forget this, is that so clients, if they come here on a tourist visa and make a switch, they want to change status. If it's done really fast, that could be an issue. If it's done as soon as they answer, that could look like they had the intent to change status and not come in on the original visa intent, for example, a tourist visa. But for example, if they come in, they're here for a couple months and realize, this is a good place for a business. Let's do an L1. I have a country successful in my home country. I'll do a branch over here. If you submit a change of status request in the U.S. while you're in valid status, and then that status ends. So let's say the tourist visa ends after 6 months. If you had filed for a change of status before it ended, and it was a valid change of status, it wasn't like just a joke to keep it going, you could stay here until adjudication happens. Now in this case, the alleged attorney had these people file a new B1 extension while the change of status was pending, because they said that, okay, we got to do extension of status because your BV is expiring. Well, that extension of status was denied. It was a no-brainer. And so these people would call me freaking out and really worried, rightfully so, saying, like, what are we going to do now? We're here unlawfully. So under INA section 212A 9B, Roman numeral 4, I think it is. Hopefully I'm not reading these wrong. Is it 6 or 4? IV. INA section 212A9B IV of the Act. I'm trying to quote it, but there's a lot to quote here. Essentially, the Act says that a person has 120 days where the unlawful presence period is tolled. So for 120 days, unlawful presence for a three-year bar is tolled, so you don't have to worry about that while it's pending. On the other end, in the USCI's memo that came out, I think it was 2009, they said that as a policy, USCIS has extended the 120-day statutory tolling period to cover the entire period during which an application for extension of status or change of status is pending. And this extension is valid for the 3-year bar and the 10-year bar. Now, the statute says differently, but this policy memo is there. It's the unlawful presence memo. I'm going to find the info so I could give it to you so you can look it up. It's the interoffice memorandum, the Neufeld memo in May 6, 2009. May 6, 2009. Consolidation of guidance concerning unlawful presence for purposes of section 212, blah, blah, blah. It's really important that you read this. I read this every year, probably once, every 6 months really, because it's a 51-page thing, and there's a lot going on in there, but to be a good immigration lawyer, you have to know this. Any type of immigration law you practice, because it's so nuanced. And when people tell you, oh, immigration lawyer is just a form, hand them this 51-page memo and have them read it, and then they're going to be like, oh, I'm sorry. You understand why immigration lawyers are there. It's some key thing to read. Again, it's a 2009 Neufeld memo about unlawful presence. It's a consolidation of guidance. Really read it. It's very important. So obviously the alleged attorney didn't read this and didn't know it and scared the bejesus out of these people. But on the other end, they, for some god-awful reason, and this is something, again, I want info@jqqlaw.com is my email. I want to talk to you about this. Please email me about the idea of whether there's strategic reasons not to do premium processing. The idea that, if you send premium processing, chances are it's going to be denied. I haven't had that experience. I 98.9% of the time send premium processing every time. I don't see in majority of cases why you shouldn't do that. If a case is weak, then don't submit it. But a case, if you're new, especially if you know your L1s or whatever it is, and you can, not like this current situation where H1B premium processing stop. But if you're doing it like an L1, there's no reason to do it unless the case is weak. Then you should just go and fix the case. Find out why it's weak and fix it. The game that, to me, that you play of not doing premium processing nowadays, it doesn't make any sense. Especially in this case where the person only has a few months on their B status, and they say let's play this game of waiting 6 months to see what happens with the L1. Now, if they had done premium processing, it was a bad case, it would have been denied, and then we could have fixed something up quickly. But it doesn't make any sense to kick the can down the road and be in this limbo and just wait for a decision. That's a really unwise decision. Now, I've done one case where I didn't file premium processing, and it was a case where we already had the new office L1. We were going to extend it. The client was purchasing 2 businesses, and the escrow and closing weren't happening until the L1 period was coming to an end. And literally on the last day, I was actually at AILA's conference last summer in Las Vegas. I had to miss 2 of the seminars because I was in that FedEx Kinko room of the Wynn, hogging the printer. So many lawyers looking at me dirty looks because I was taking over the place because I had to file an L1 at the last second. The client didn't give me the paperwork the last second. And because I didn't know what was going to happen in this case, I made the executive decision. I said, listen, we're not going to do premium processing because if you give me some bad paperwork, I don't want to do premium processing really quick and then have it denied within a couple of weeks or months or wherever, and then all of a sudden you got to leave the U.S. and have your business here. I prefer to do the long, drawn-out way of doing L1 processing and have it linger on forever. And that way, if we see that the case is weak once I review the paperwork, or maybe I submit it, you gave it to me on the last day, I can't read things that fast. I only have 24 hours to submit something. So I did my best. I submitted it, and I said we can't do premium processing. Now, the case, when I finally put it together, actually was a good case. And without pre and processing, was approved at 2.5 months. This is we filed in California. I think we sent it to California Service Center, even if it's not pre and processing. So it got approved in 2.5 months because it was a good case. The guy bought 2 additional stores, and the kind of chain he had, all of a sudden his employee numbers boosted, and the income sheets from his business were good, and everything was a good case. But I didn't know that because they were waiting until the last second. I said, that's an exceptional case that I wouldn't do that. But other than that, I try to file my L1s many months before the due date is happening, so I can make sure if we get an RFE that's really bad, we could just maybe undo the case, just withdraw it, and then resubmit L1 and fix what the issues are. That hasn't happened, but that's the kind of strategy I like to do. Give me more opportunities at bat to fix it while they're here instead of sending the poor people overseas and God knows what would happen. So, email me if you don't think pre and processing for an L1 is appropriate. Do you think, sometimes the service center is not good or this? Let me know why, and I'd like to get other ideas. That'd be another perspectives. That'd be very helpful. Now, nearing the end of everything, I did want to leave everyone with a tip, which I try to do at the end, which is to get global entry. The global entry program is this wonderful program where you go to the airport and you're not groped, and there's no line. You go there, you don't have to wait in line. You go late to the airport right before your flight. You just go in very fast. The program is so underutilized, probably a quarter of the number they thought they would, that it's like having luxury first class service to enter an airport. It's only $100. I think TSA PreCheck's $80. If you have an American Express, some American Express cards, they even pay for the global entry. So go get global entry. It's a very easy process. You have to have a clean background, this and that. You have to do an interview, which is pretty much, what's your name, why do you want it? It's a very simple interview. You have to go to CBP office in your area, in your airport, and do it. But there's no reason not to. I got it. I'm looking forward to using it. I'll probably be traveling pretty soon, so I'm really excited. I'm going to just pass through that, no taking off. I'm not sure if you have to take off the shoes or not, but it's just a regular metal detector for the most part. So it's something you should definitely do. Do the global entry program. Now, they are strict. If you have any indication of wrongdoing, that could be something that'll deny you. Like, for example, if you had gotten an apple on a plane once coming from an international flight, and you had it in your purse or your bag, and you came into the airport, an agricultural check asked you if you have any food, and you just pulled out an apple, that's an immigration violation. You're not going to get global entry. So if you have this, they say at CBP, this is the cleanest record. But if you're already a lawyer, chances are you already have a clean record. We already did our stuff like that. So it's something to use. It's not expensive, and it makes travel so much easier. Imagine not having to go so early to the airport, not having to wait in that stressful line. It's worth $100 for a couple of years. The thing about it is, and here's some more tips, there's a big interview line. So when I signed up for it, they said, okay, come in 9 months. It's an online system. The only open date for interview is 9 months. I was like, horrible. I can play 9 months. Well, there's a trick to it. After you do that, wait 24 hours, go back in the system, and keep checking. Spots open up. So you could get a 9-month date in the future, and then go back into the online scheduling system, and all of a sudden see a spot open up in 2 weeks. And you could just get it in like that. So some massive tips. Please do that. It's going to help your life. And the whole program is underutilized. So if you don't use it, that might be some reason they might even cancel it maybe because it's not being used, not worth the money. So I'm going to leave you with that. Thank you so much for listening. I enjoyed this so much, and I enjoy the interaction, the emails I get from you. It's a pleasure working with our community, and I really want to use this to develop a great bond on the legislation stuff I talked about accumulating information that can help all of us, helping all our practices better, about learning these nuances in the law, and just the camaraderie and the friendship that develops. Please email me, info@jqqlaw.com. The website is Immigration Lawyers Podcast. If you want to join the Immigration Lawyers listserv, if you are a lawyer, email me, info@jqqlaw.com with your proof of that you're a lawyer, and let me know which listservs you want to join. You can join all of them. The list is immigrationlawyerslistserv.com, and you could get the information there. If you're watching this on YouTube, please like and leave a comment, hopefully a positive one. And if you listen on iTunes, definitely follow, leave a nice review. And if you try to leave a review and it doesn't work, let me know, because when I go on different computers and I press it, there's something going on on my iTunes that doesn't let me leave my own reviews. So I think it's a glitch, but maybe I'm doing it wrong. Let me know. This is John Khosravi, and I really enjoyed it. Hope you had a good time, and I hope you enjoyed this week. Until next time, have a great one. Bye-bye.